So hello and welcome to today's employment law update with Keeley Baigent of KSAB Law. Today we're going to cover case law developments in the areas of working time regulations, unfair dismissal, part-time worker discrimination, disability discrimination, sex discrimination and harassment. So today's session is going to be recorded and sent to you probably in about a week. Please do feel free to ask questions as we go along using the chat box as usual, and we'll answer them as soon as we can. So I'm going to pass over to Keeley, and I hope you enjoy today's session.
Hello everyone and welcome to today's HRHuddle. So Eloise has kindly given me an introduction and detailed what hopefully we'll be covering today. Please feel free to ask any questions as we go along in the chat box, as Eloise has said. So the first topic that we're going to cover is the working time regulations, but also within the case I'm going to refer to, it does make mention also of an automatic unfair dismissal claim that actually refers to or relates to the working time regulations. I'm going to share my screen and go through the slides. So hopefully that you can all see those. So the first case then I want to refer to is that of Simos and Decide UK Limited. The case concerned Regulation 11 of the Working Time Regulations, which actually states that an adult worker, so an adult worker, is entitled to an uninterrupted rest period of not less than 24 hours in each 7-day period during which he works. So in addition, as I said, this case deals not only with or makes reference to that regulation, but also the claimant brings an automatic unfair dismissal claim. And one of the automatically unfair reasons for dismissal, as listed in the Employment Rights Act, is a dismissal by reason of asserting a statutory right. So the facts of this case are that the claimant's employer instructed her to cover a colleague's pre-booked holiday. She initially accepted that instruction, but on realising this meant she would work 14 consecutive days in breach of Regulation 11, she asserted that the proposal was treating her like a slave. So that's what she asserted at the time that the employer made the instruction. The claimant's employer refused to hire temporary cover, and the claimant actually provided the cover, but was later dismissed by reason of the earlier complaint, i.e. the complaint that she said, well, you're treating me like a slave. So what do you think then? If the claimant then, as she did, brought a claim of automatic unfair dismissal, asserting that she was dismissed for asserting a statutory right, do you think that that claim succeeded? Well, the tribunal dismissed the claimant's claim of automatic unfair dismissal and held that she hadn't been unfairly dismissed. And it made that decision based on the fact that the claimant's complaint for which she had been dismissed, i.e. the breach of Regulation 11, actually hadn't occurred. So the employer dismissed her for the complaint she made, but at the time she made the complaint, the breach, i.e. working 14 days without an uninterrupted rest break, had not yet occurred. She appealed the EAT, and the EAT disagreed with the Employment Tribunal and held that she had been automatically unfairly dismissed. They said that the claim actually crystallized at the time she made the complaint, when she said, you're treating me like a slave. So that was the point at which she asserted the breach of a statutory right, and that is the reason for the dismissal. And it was irrelevant that actually the breach hadn't occurred at the time. Moving on then to ordinary unfair dismissal, and in particular in the context of final written warnings. So in the case of Falahai and TWI, the EAT considered whether In an unfair dismissal case relating to a capability or a conduct dismissal, an employment should reevaluate the merits of a final written warning that was relied upon in dismissing the employee. The background of the case is where there is a potentially fair reason for dismissal, i.e. one of the 5 reasons listed in the Employment Rights Act, example, conduct or capability. The tribunal will consider whether the employer acted reasonably in treating that reason as a sufficient reason for dismissal in the circumstances. So that's the law. So the tribunal will decide whether or not the dismissal falls within one of the 5 potentially fair reasons, and then it will consider whether or not the employer acted reasonably in treating that reason as a sufficient reason for dismissal. Any warnings that are received before the dismissal may be relevant in determining the reasonableness of the dismissal, particularly where, of course, an employer relies on a final written warning in then proceeding with dismissal. The general law is that an earlier warning must be regarded as valid by the tribunal unless the tribunal is satisfied that the warning was issued for an oblique motive, it was manifestly inappropriate, or it was not issued in good faith nor with prima facie grounds for making it. So that's really important, and it's helpful for employers because ultimately the tribunal starts to position where the warning, the final written warning that the employer is relying upon in dismissing the employee is valid unless it is manifestly inappropriate or prima facie inappropriate. So the facts of this case then were that the claimant employee was employed by the respondent as a senior project leader. The employer raised concerns about the employee's performance and invoked a performance management process. At a subsequent capability hearing held under the employer's disciplinary procedure, the employer moved directly to issuing the claimant with a final written warning. Now, usually, as detailed in the ACAS Code of Practice, an employer would usually go from first written warning, then monitor, and then a final written warning, then monitor, and then dismissal. But this employer jumped straight to a final written warning. A 3-month review period was then put in place, and after 2 months, it was reconsidered, and it was determined that the claimant had made insufficient progress. And so the employer then jumped straight to a formal capability hearing and dismissed in reliance on the final written warning. So the employment tribunal found that the dismissal was actually fair. The tribunal considered that the final written warning was valid, and it took account of it in determining whether the employer had acted reasonably in dismissing the claimant. So the claimant appealed to the EAT. The EAT agreed with the employment tribunal and dismissed the appeal. It held the tribunal had been entitled to find that the final written warning was valid in the circumstances. The AT considered the final written warning, even though there hadn't been a previous first written warning, was not manifestly inappropriate, and there was no basis, therefore, to look behind it. The AT confirmed the limited scope for going behind a final written warning when considering the fairness of a dismissal when relying upon a final written warning. The tribunal, in these circumstances, it said, are required to look at all the case, all the facts to determine reasonableness and not simply whether the final written warning was reasonable or appropriate. Although the warning was a relevant factor in determining reasonableness, it said it was only one of the factors. And here the employer had been dealing with the continuum of the employee's performance over a long period of time, part of which had led to the final written warning. In the circumstances, it was determined that the tribunal was entitled to find the warning was not manifestly inappropriate. So I think that case is a helpful case for employers dealing with performance issues in particular in respect of employees, because the starting point, as I said, has been confirmed to be that a final written warning that is relied upon in dismissing an employee will be considered valid unless it is found and put forward and found that the final written warning was manifestly inappropriate. Just a mention of a conduct dismissal in these situations as well. So if an employer relies on a final written warning in respect of a conduct matter, it's again the case that the tribunal will not look behind that final written warning unless it's found to be manifestly inappropriate. And of course, in those kind of situations, once you've got a final written warning on an employee's file, then if the employee commits any act of misconduct, it does not need to be related to the subject matter or for which the final written warning was issued, then you may proceed, obviously if it's reasonable in the circumstances, to dismiss in reliance on that final written warning. So the case law appears to be more favourable, I think, to employers than it did historically. Moving on then to consider unfair dismissal, but in the area of appeals. I want to bring your attention to this case, which is Gwynedd Council and Barrett and others. So in this case, the Court of Appeal had to decide whether the employer's failure to give employees the right of appeal resulted in the redundancy dismissals being unfair. So what do you think? If an employer follows a fair procedure, fair selection procedure, would the dismissal be fair if the employer fails to offer the employee or allow the employee to appeal? So let's have a look. The facts of the case then are that the claimants were teachers who were dismissed by reason of redundancy. The claimants were dismissed when their school closed and a new one opened on the same site, which seems a bit odd. There was no consultation over the closure and there was no appeal offered. The employees' applications for new roles at the new school were unsuccessful. The teachers had been denied both their statutory and contractual right of appeal in the circumstances, and therefore they brought claims of unfair dismissal. So the employment tribunal in the case held that there is a requirement that only in truly exceptional circumstances employers can refuse an appeal. And on that basis, the employment tribunal found that the dismissals were unfair. Because of that finding, the employer, the school employer, appealed to the EAT. Now, the EAT agreed with the employment tribunal that the employees had been unfairly dismissed, but this was not on the basis solely of the employees not being given the right to appeal. What the EAT said, that there isn't a general rule that says an employer must, except in exceptional circumstances, offer employees the right of appeal. But the EAT did say that in this case, the general reasonableness of the process, i.e. the lack of consultation, the lack of opportunity for the employees to raise grievances, the whole procedure made the dismissals unfair, not simply the lack of opportunity for them to appeal the employee's decision to dismiss. So I think then that again is quite helpful, because what it's saying is, in answer to the initial question, if an employer does proceed with a good and fair and reasonable procedure in making employees redundant, but then doesn't offer them the right of appeal, it does not necessarily mean that claims of unfair dismissal will succeed. So as long as you follow that fair procedure, and obviously we would always advise that you do offer employees a right of appeal, but if you don't, as long as you have followed a good procedure initially, then this may still mean that claims are not unfair, claims of unfair dismissal do not succeed. Sticking with the area of appeals, this next case, which is that of Moore and Phoenix Product Development Limited, deals again with the question, a similar question, which was, can a dismissal be fair if the employer refuses to hear an appeal? This case, however, didn't deal with redundancy. It actually dealt with a dismissal for the reason of some other substantial reason. So as you know, these 5 potentially fair reasons listed in legislation that an employer has to dismiss an employee for, and then the procedure in dealing with the dismissals for that reason needs to be considered. So one of the potentially fair reasons is called some other substantial reason, and that sits alongside conduct, capability, redundancy, and a contravention of a statutory duty. The some other substantial reason is really a catch-all category in respect of reasons that don't fall easily into the other reasons as listed in the legislation. So examples of dismissal for some other substantial reason include dismissals further to business reorganisations that don't fit into the category of redundancy, and they might be in situations where there's a third party pressure to dismiss. So what do you think then? Based on what we've heard in the previous case, do you think that by an employer failing to hear an employee's appeal of their dismissal in respect of a dismissal by reason of the employee's conduct or capability or for a substantial reason, do you think that would make that dismissal unfair? So that's the question that was considered in this case. The facts of the case are that the claimant was the inventor of a water efficient toilet. The claimant stepped down as CEO of the respondent. Although he stayed on as a director and employee, the claimant had difficulty accepting he was no longer leading the company. The claimant had met with the new CEO and agreed to make things work. However, he was combative, he sent aggressive emails containing foul and abusive language and was generally difficult. The situation worsened until eventually the claimant was dismissed. The claimant's attitude at the board meeting where he was dismissed was confrontational. The claimant was dismissed due to, and the reason given was an irretrievable breakdown in the employment relationship. And this came under the category of some of the substantial reasons listed in the legislation, alongside conduct and capability, which we've looked at. The claimant was not offered the right of an appeal. So the claimant brought a claim in the employment tribunal. The tribunal rejected his claim, noting that the appeal would have been absolutely pointless in the circumstances and that the claimant was entirely responsible for the breakdown in the relationship. The claimant appealed to the EAT. The EAT upheld the employment tribunal's decision. It held that an appeal will normally be part of a fair procedure and could lead, therefore, to the claim being the claim of unfair dismissal being successful, but not invariably so. The relevant circumstances should be taken into account. The EAT referred to the respondent employer being a small organisation. Relations had broken down, the claimant had been in a senior position and was unrepentant. And on this basis, the AT determined that the tribunal was right to find an appeal would have been utterly futile. And therefore, the fact that the appeal wasn't offered or granted didn't make the dismissal unfair. So again, another reassuring decision for an employer, reiterating the fact that in respect of all reasons as listed in the Employment Rights Act, the 5 potentially fair reason, if an employer fails to grant or offer the employee the right to appeal, it may not be futile. It may not necessarily mean that an unfair dismissal claim succeeds. So, Sticking with the area of unfair dismissal, but moving on to the area of conduct, I'm going to bring your attention to the case of Mr. Rathod and Pendragon Sabre Limited. In this case, the employee, Mr. Rathod, brought a claim of unfair dismissal, ordinary unfair dismissal. Just a warning on this, it does contain some comments and statements that you may find offensive. So just a warning and to bear that in mind. So the facts of the case then. Mr. Rathod joined the Porsche dealership in Sutton Coldfield, operated by the automotive retailer Pendragon. He joined in 2018 as a sales executive. He was the only non-white member of all-male sales team and was repeatedly referred to as Chibati and Papadom. In the Employment Tribunal judgment, Employment Judge Clark described the workplace as laddish, crude, and immature, where conversation included graphic and sexual references. The judge said the culture developed a more sinister level as it was infected by the overt prejudices, opinions and attitudes of some of its members, which included aggressive expressions of misogyny, hostility towards homosexuality and racism. The phrase "lick my dick" was commonly used on the sales floor. It was found that Rathod did not did what he could to get on with his colleagues. The judge accepted his description of being an outsider and having to conform to the existing team culture, manifesting in him being subject to some extreme examples of bullying and harassment, which targeted his ethnicity. However, the judge stated the following: nothing in these findings should suggest that Mr. Rathod was silently suffering. Conforming meant he not only had to accept his treatment, but actually to participate in it. But put simply, it appears to reflect the classic situation where the bullied finds himself mirroring the behaviour of the bullies to be accepted. The judge referred to one occasion when a cupcake was held over the claimant's head while he was on the telephone, only for it to be smashed into his head as the call ended. On another, a video of the claimant eating Asian flatbread with his fingers was shared alongside comments about how disgusting it was. One of the a terrible situation took place on a day off when Mr. Rathod brought McDonald's in for the sales staff who were working. One of the team threw a banana on the floor at his son, saying, I want to see how he reacts," and laughed intensely. Customers of apparent Asian origin were referred to as Rajiputs, and vehicles arriving with more than one Asian customer were referred to as buses. When the first national coronavirus lockdown began on 23rd of March 2020, Mr. Rathod set up a WhatsApp group named Porsche Sutton Coldfield for the sales team, including 2 managers who had been furloughed. This group and numerous one-to-one exchanges occurred in the group and allowed the extreme laddish behaviour to continue. Mr. Rathod returned to work after 3 months of furlough and spoke with one of the managers about his experience on the team. He said he was sick of the banter, particularly from a colleague referred to as O, and that it was making him feel uncomfortable. The judge said that the manager's response was dismissive, which may have reflected his perception that Mr. Rathod gave as good as he got. Mr. Rathod went off sick with stress, anxiety and depression from September 2020. He attributed his absence to the situation with his colleagues, which prompted him to raise a grievance, alleging that various colleagues had racially harassed him at work, including specific allegations against O. The judge found that the grievance was taken seriously and was partially upheld, finding in favour of a number of Mr. Rathod's allegations, including the particularly serious ones. Disciplinary proceedings were commenced against O, who promptly resigned. Now, during the initial grievance investigation, O had defended his conduct on the basis that he and Mr. Rathod were friends, that they had a good working relationship, and that Mr. Rathod behaved in the same way. O submitted various screenshots from his phone to actually demonstrate this and evidence it. Mr. Rathod had insisted that he asked O for the comments to stop, but in the formal grievance outcome, the investigator said the following: after investigating this point and after O stated you actually engaged in this sort of conversation yourself, I am unable to agree with your point. Further, I am in receipt of some messages between yourself and O to confirm his side of events. Given the gravity of the messages I have since been privy to, I have no alternative other than to also investigate these points with you. So that then resulted in December 2020 with Mr. Rathod being invited to a disciplinary meeting. And at that hearing, Mr. Rathod accepted that he had sent the messages and that they could be deemed offensive. He described all the crude phrases and comments he had made as not being the language he would ordinarily use, and he had not brought it to the company. He had engaged in this type of behaviour to participate in being accepted, and because he wanted to keep his job and to be part of the group, and he said he had no choice. Mr. Mason, who conducted the disciplinary hearing, concluded, banter is okay until it's not okay. Referring back to our dignity at work policy, you have contravened several points in here. Factually, when it comes to harassment of a sexual and racial nature, as a company, we have a zero tolerance towards it. My view and my conclusion is I have no alternative but to dismiss you. Mr. Rathod appealed, but that appeal was dismissed. Mr. Rathod subsequently brought a claim of unfair dismissal. So what do you think? Do you think the Employment Tribunal found that Mr. Rathod had been unfairly dismissed? The Employment Tribunal, Mr. Judge Clark, held that Mr. Rathod had been unfairly dismissed. In his judgment, Judge Clark said there was clearly a glaring issue in need of addressing in view of the evidence that had emerged from Mr. Rathod's original grievance and later disciplinary. If the mantra of zero tolerance is to be accepted, one might feel entitled to expect there to be evidence of that investigation and further disciplinary action. The employer had a solid basis for at least suspecting, if not evidence to believe, that others had conducted themselves in the same way as O and Mr. Rathod. It causes me to find that the respondent's assertion of a zero tolerance to this type of conduct is simply not the case. On that basis, Mr. Rathod's claim of unfair dismissal succeeded. The judgment saying the messages were a product of the culture Mr. Rathod came into and which had been allowed to normalise without censor or the employers by the employer's lower management. So on the face of it then, you would have thought that the dismissal was potentially fair if there was so much evidence that Mr. Rathod had sent those offensive messages. But what the tribunal really does highlight is that there was disparity of treatment. And so although the employer believed it was dealing with the matter by taking disciplinary action against O and Mr. Rathod, there was clear evidence that it was rife. The culture was such that there was so many other employees involved in this. And by taking disciplinary action against just 2 employees when it seems the whole team were involved, was unfair to Mr. Rathod. So it's essential, isn't it, in these kind of situations that an employer trains its staff appropriately so they're fully aware of what is acceptable conduct in the workplace, and that if disciplinary proceedings are taken against employees, that there is equal treatment in respect of those disciplinary proceedings. Sticking then with the area of discrimination, well, we've moved on actually because that was unfair dismissal, although it dealt with the issue of harassment. We're going to look at disability discrimination. and in particular in respect of the category of discrimination arising from disability. In this case, the case of Stoat and Raleigh Limited, the EAT was required to consider whether the employee's dismissal was discriminatory when the employer only knew about the disability after dismissal. So I'm just going to whiz through this really, because I think it's important for you to, for me to bring your attention to the case. As I say, but I'm not going to go into a huge amount of detail. So as I say, the case concerned the category of disability discrimination called discrimination arising from disability. And that occurs where the employer treats the employee unfavorably because of something arising as a consequence of the employee's disability, and they can't show that that treatment is justified in the circumstances. In order to succeed in that kind of claim, and an example of that category of discrimination is where an employee is dismissed because of their long-term sickness absence, which relates to their disability. So they're off work because of their disability for an extended period, and then are dismissed because of the long-term sickness absence. So that's the category. In order to succeed in that claim, the employer must have knowledge of the disability. Now, that probably goes without saying, because unless an employer knows about the disability, then how can they discriminate on grounds of the disability or something arising because of consequences of that disability? So you would have thought that would go hand in hand, and it's understood that it has to be actual knowledge, but it also can be constructive knowledge. And constructive knowledge means that the employer should have reasonably been expected to know about the employee's disability based on the circumstances. So they may not have been told by the employee or the employee's doctor that the employee is suffering from a condition that may well satisfy the definition of a disability. But based on the employee's demeanour or based on the snippets of medical information the employer has, they should have constructive knowledge. They should reasonably be expected to be aware of the disability. So the facts of this case were that the claimant was actually dismissed because of her poor performance within her probationary period. Now, at the time of the dismissal, the employer didn't know that she had a disability. She subsequently raised a grievance about her dismissal. She wasn't offered the right of appeal. So she raised a grievance, and during the grievance process, she told the employer that the reason for her poor performance was because of her disability, a mental health disability. She didn't succeed in her grievance. She then brought a claim in the employment tribunal, and the employment tribunal held that she couldn't succeed, or she didn't succeed in her disability discrimination claim because the employer did not know about her disability and didn't have constructive knowledge at the time that they dismissed, even though they became aware of it subsequently at the grievance stage. They didn't know about it at the time of the dismissal, and the dismissal could be separated from the grievance process. So again, I think that's a helpful case for employers to be aware of, that, you know, employees are not going to succeed unless, in these cases, unless at the time of the alleged act, the employer has actual knowledge or constructive knowledge. And then sticking with the area of disability discrimination, but looking at the area of that of failure to provide reasonable adjustments, I want to bring your attention to the case of Aleem and E-Act Academy Trust Limited. So as we know then, if an employee has a disability as defined in the Equality Act, the employer may then have an obligation to make reasonable adjustments. The duty to make reasonable adjustments applies if there is a provision, criterion or practice that places a disabled employee at a substantial disadvantage in comparison to those who are not disabled. In such a situation, as I said, the employer must take such steps as are reasonable to avoid the disadvantage. So, making a reasonable adjustment. The facts of this case then are that the employee was a science teacher. She was absent from work for a period as a result of problems with her mental health. The Respondent Academy Trust accepted that the employee's mental health rendered her a disabled person for the purposes of the Equality Act, and the respondent allowed the employee to return to work 4 days a week, with other science teachers picking up the 5th day, so a reasonable adjustment being made. However, the teacher's health again declined, and she asked to teach 2.5 days per week instead of the 4. An occupational health report confirmed that the employee was unfit to work full-time, but could work part-time. The respondent, however, could not accommodate the employee's request to work as a part-time teacher, less than 4 days, because of problems recruiting to fill the other days, which is a common problem, isn't it, for employers when flexible working requests are made in respect of a full-time job. The respondent instead offered the teacher the option of returning to work for 3 days per week as a cover supervisor. So this is a different role to a teacher. That role was paid at a lower rate than the employee's teaching role, but the respondent agreed to pay the teacher at the teacher's rate for an initial 3-month probationary period. The employee sought to be paid at the teacher's rate in the supervisor role on a permanent basis, but the school, the respondent, refused to do so and said it wasn't a reasonable adjustment to do that. The employee raised a grievance, but it was rejected. She was paid at the teacher's rate in the end for 9 months while her grievance was being dealt with. The employee subsequently brought an employment tribunal claim for disability discrimination, arguing that the employer's failure to pay her at the highest salary on a permanent basis was a failure to make a reasonable adjustment. So what do you think? Do you think the employment tribunal found that it would have been a reasonable adjustment for the employer to have paid the employee at the higher rate on a permanent basis? The employment tribunal found that the respondent employer was already facing financial difficulties, and it was not a reasonable adjustment for the employee to be paid at the higher rate indefinitely. The employee teacher therefore appealed to the EAT, and the teacher submitted that there was no evidential basis for the tribunal's finding that the respondent was already facing financial difficulties, and the respondent had never suggested that it could not afford to pay her at the higher rate. The EAT dismissed the teacher's appeal, and it agreed with the employment tribunal and found that there wasn't a case for the employee, i.e. there was no obligation on the school to pay the employee indefinitely and permanently at the higher rate. Again, that is a helpful case for employers. However, a point to note, an employer doesn't have to show that they are in financial difficulties to be able to defend a claim like this. However, what it does need to evidence is that it will put a strain financially on it by paying an employee at a higher rate in a lower status role, offering them a reasonable adjustment, that it will put the strain on the employee financially, which is exactly what this school did. The school didn't actually give evidence that it would face severe difficulties if that occurred. However, it did say it's going to cost us thousands of pounds for this to be offered to the teacher for an indefinite period and until she retires. So that's the first point. So as long as the employer can present a reasonable argument that it will put a financial strain on it if the pay is protected indefinitely, then that will assist the employer's case. And also, in this case, it was made clear that the protection, the pay protection, was only going to be for a temporary period. So if an employee is being offered a lower status role that attracts a lower salary to satisfy the employer's obligation to provide a reasonable adjustment, then as long as the employer makes it clear that that is, and it's protecting pay for a temporary period, then that again will be helpful for the employer to justify any allegation that they fail to provide reasonable adjustments. When I advise clients in this situation, I always say, we need to consider whether we can pay the higher pay. If we can't, we need to try and present some evidence to support that. But ultimately, there is no obligation to meet that higher salary in the lower grade post, generally. Now, the next case is still in the area of disability discrimination. And it's the first case, it's a first instance case, but it's the first case that actually demonstrates and has found that an employee can succeed in a claim for disability discrimination based on somebody else's disability in respect of an indirect disability discrimination claim. So it's a bit of a technical point and something that I want to bring your attention to, but hopefully when I go through the facts of this case, it'll become apparent that it is actually quite applicable to a lot of employers. So the case, the background to the case, well, the case is that of Fallows and Nationwide Building Society. The background to the case is the categories of direct discrimination and indirect discrimination. So dealing with direct discrimination first, this occurs when a person is treated less favourably than another because of a protected characteristic. So it's less favourable treatment because of a protected characteristic. So in this case, somebody's disability. In a direct discrimination claim, it is necessary for the claimant to point to a real or hypothetical comparator. So they have to say, I have been treated less favourably because of my protected characteristic, and I can point to Mr. Smith, or I can point to a hypothetical comparator to demonstrate that, to support my case of less favourable treatment. Now, for direct discrimination to be established, there is no requirement that the less favourable treatment is because of a protected characteristic of me, of the victim. Direct discrimination can occur where the reason for the less favourable treatment is the protected characteristic of someone with whom the victim or the complainant associates with. So it could be based on somebody else's race. So I'm treated less favourably because of somebody else's race, or I'm treated less favourably because of somebody else's disability. In indirect discrimination cases, this occurs where there's a provision, criterion or practice which is applied to a group, but it puts persons with whom the complainant shares a protected characteristic at a particular disadvantage, and it puts the complainant at a particular disadvantage. And that treatment cannot be justified. So this is a bit more complicated. So it's where an employee, so a provision, criterion or practice could be where I require as an employer for employees in this particular role to work full time. And that puts female employees at a general disadvantage because they have the majority of, generally have the majority of childcare responsibilities, and then the employer has to show, or I have to show, that that practice is justified. For indirect discrimination to be established, the law at the moment, or before this case, was that the claimant personally has to suffer the disadvantage and be put at the disadvantage. They can't point to somebody else and say, they've suffered the disadvantage, I've received, they've based on their race, based on their sex, I've suffered the disadvantage. It has to be the victim's protected characteristic. However, that conflicts with European law. So this is a case, first instance case, that considers whether or not our law should actually be changed alongside EU law in respect of this, i.e. should we be able to, or should a person be able to succeed in an indirect discrimination case based on somebody else's protected characteristic. So hopefully this will clarify matters a bit more when we go through the facts. The facts of the case are that Mrs. Fallows was employed by Nationwide Building Society as a senior lending manager, which I'll call SLM, from December 2011 to when she was dismissed in January 2018, allegedly by reason of redundancy. Throughout that time, she was employed on a home worker contract. And she, and therefore, principally, the majority of her time was spent working from home. She did come into the office for 1 day, 2 days a week, if necessary. The primary reason for working from home for Mrs. Fallows was because she was the carer for her disabled mother. Nationwide's management was aware of that reason and permitted her to continue working from home on that basis. Although Mrs. Fallows was employed on a home work contract, she did attend the office, as I've said, 1 or 2 days per week. She had high ratings and appraisals throughout her employment, and in particular had a documented history of excellent supervision of individuals within her team. A decision was taken by the employer to reduce the number of SLMs from 12 to 8, and that all SLMs would need to be office-based. Nationwide's reasons for the role for the office-based were firstly a greater need for staff supervision by SLMs due to a change in the nature of the work, and secondly, feedback from junior staff which suggested dissatisfaction with the level of supervision provided to them. As a result, Mrs. Fallows' role was put at risk of redundancy and a consultation process began. There were more than enough volunteers for redundancy to meet the required reduction in SLM headcount. Mrs. Fallows did not volunteer for redundancy as she wanted to stay in employment. Throughout the consultation process, she informed Nationwide of her wish to retain her existing arrangement of working from home and attending the office, which she believed was feasible going forwards. Despite this, Nationwide approached some of the volunteers for redundancy to stay, and then they dismissed Mrs. Fallows by reason of redundancy on the basis that she couldn't fulfill the requirement of her working in the office all the time. Mrs. Fallows' colleague, Mr. Gregory, who was not disabled and was not a carer of a disabled person, was also employed on a home worker contract. He received essentially the same treatment as Mrs. Fallows and was also dismissed. Mrs. Fallows brought claims including direct and indirect associative discrimination on the grounds of her mother's disability. So she's saying, I've been treated unfavourably in respect of direct, and then the other argument in respect of indirect because of my mother's disability, not mine, but my mother's. So let's have a look then at what the tribunal decided. Now, in respect of the direct discrimination claim, i.e. less favourable treatment on grounds of her mother's disability, the claim failed because the employer was able to point to Mr. Gregory, who was in the same circumstances as Mrs. Fallows and had also been dismissed. But he wasn't caring for a disabled person, nor was he disabled. So what I'm saying, so Mrs. Fallows couldn't succeed in the claim that she had been treated less favourably because of her mother's disability, because Mr. Gregor was also dismissed, who was also dismissed, but he didn't have a disabled mother that he was caring for. So same circumstances, different circumstances in terms of the caring responsibilities, same outcome. So the direct discrimination claim failed. Now, in respect of the indirect discrimination claim, the law at the time, the English law at the time, was that indirect discrimination claims could not be brought based on somebody else's protected characteristic. However, for the first time, the tribunal have decided that this claim should succeed, and Mrs. Fallows therefore did succeed in her indirect discrimination claim based on her mother's disability. So the provision relied upon was the requirement that SLMs could no longer work at home on a full-time basis. So that's the provision. The employer says now everybody, all you SLMs have got to now work in the office on a full-time basis. The tribunal accepted as a general proposition and self-evident fact that due to their care commitments, carers for disabled people are less likely to be able to satisfy a requirement to be office-based than non-carers. So that's the next bit of the test. As such, the requirement to no longer work at home put Mrs. Fallows at a substantial disadvantage because of her association with her mother's disability as her principal carer. So the definition, the first part of the definition is satisfied. The provision is all SLMs need to work from the office now. That put Mrs. Fallows at a disadvantage, substantial disadvantage, because of caring responsibilities in respect of her mother, not her, her mother. Now, can that be justified? Well, the tribunal said no, it wasn't justified in the circumstances, because there was evidence to suggest that, well, the aim to be achieved by the employer was that there was adequate supervision for all junior staff in the workplace. And that's the reason why they wanted to implement the provision of everyone working full-time from the office. However, it wasn't a reasonable step to dismiss Miss Fallows because of that, because actually there was evidence to support the fact that she had a good record of supervision of junior staff when working from home, and she could achieve that aim, i.e. adequate support, by coming into the office 1 or 2 days a week, which she had done before. There was no evidence to suggest that supervision of junior staff could not be achieved by her working from home and coming into the office 1 or 2 days a week. So she succeeded in her indirect discrimination claim. I think that's a really important case. I know it's a bit complicated, but I think it's an important case because employers are grappling now, aren't they, with bringing employees back from working at home. So not only are they going to potentially have to deal with situations where employees are saying, because of my child caring responsibilities, I can't now return to the office full time. They're also going to potentially have to deal with, I can't return to the office full time because I've got to look after a disabled person in my household. So, and because of this case, those situations are going to have to be taken very seriously. Moving on then to the last couple of cases. So the first one relates to sending a pregnant woman home to avoid COVID risks. It's a first instance decision again, i.e. an employment tribunal decision. And as I said, it relates to sending a pregnant employee home because of COVID risks. Although it's a decision that relates to the first lockdown period, because of what's going on at the present time, I think it's still relevant for today. And it's the case of a PROSA against Community Gateway Association Limited. The facts of the case then are that Community Gateway supports around 6,000 vulnerable tenants in social housing. The claimant, Ms. Prosser, advised her employer that she was pregnant on 13th of March 2020, that is 10 days before the first lockdown. The respondent sent her home based on the government guidance at the time. It considered pregnant women to be clinically vulnerable. Although she was on a 0 hours contract, the respondent actually paid the claimant full pay whilst she was at home, so she wasn't out of pocket. The claimant claimed that actually being sent home was an act of sex discrimination. And this is a real dilemma for employment tribunals, because on the one hand, it makes no sense to find that an employer is liable for sex discrimination if it's following government guidance and designed to protect pregnant women. But on the other hand, how can sending a worker home and denying them access to the workplace not amount to unfavourable treatment? So it is a really tricky one for an employment tribunal to make a decision against. The tribunal's caught between a rock and hard place. It dismissed the claimant's claim on the basis that sending her home was not unfavourable treatment. But I think that decision was based really on the fact that she suffered no financial disadvantage and the employer actually paid her on a 0 hours contract whilst she was off. So they were able to get around it that way. An alternative approach might be that the employer was meeting its health and safety obligations under the Health and Safety Act, but that argument wasn't run in the case. And then just finishing off then with a sexual harassment case. It's concerning a hotel, and as I say, it's concerning the area of sexual harassment. So sexual harassment then occurs when a person engages in unwanted conduct of a sexual nature, and the conduct has the purpose or the effect of violating another person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. The facts of the case are that a teenage waitress commenced work at a 4-star country hotel in July 2019 in what was her first job. Whilst working a shift in the restaurant, she entered the kitchen where a conversation of a sexual nature was taking place between some of her colleagues. The head chef, who was not identified in the proceedings, then asked her, "Would you do it for money?" She was immediately embarrassed and uncomfortable by this comment and answered no. She complained to the hotel the next day, but received no response. She was left confused about what to do after the company did not take any action following her complaint. She said she felt let down by the hotel as she has since lost her confidence, and she says she finds it difficult to trust managers and others in authority. She also said she was worried it was going to happen to her again at work, and had asked her manager not to work with the head chef again. She was then placed on furlough from April 2020 due to the pandemic, but was told there were no hours for her when the hotel reopened in August, even though other waitresses returned to work. She was also removed from the employee WhatsApp group, which was used for allocating shifts. The waitress subsequently brought a claim of sexual harassment in the employment tribunal. What do you think? Do you think she succeeded? So at the hearing, the employment tribunal did uphold her claim, unsurprisingly. At the hearing, employment judge Claire Ward said of the chef's "do it for money" remark, this was clearly unwanted conduct. It was of a sexual nature and had the purpose and had the effect of violating the woman's dignity and creating an intimidating environment for her to the extent that she did not want to work with the chef again. On that basis, the tribunal ruled that the claimant had been the victim of sexual harassment and ordered the hotel to pay the claimant £18,409. The claimant's award included £5,877.30 in loss of earnings and £8,000 for injury to her feelings. So, I mean, one may think that the award in that case is high, but what it does is it reminds us that these cases are about the effect on the individual. So the injury to feelings award is about how the discrimination affects the particular individual. And now in this case, she lost her confidence. It was her first job. She doesn't feel that she can work. She finds it difficult to work with managers, male managers in the future. And so that reflects the level of the award. An expensive remark. So that concludes my presentation today on that cheery note. And a Merry Christmas to you all.
Brilliant. Thanks, Keeley. That was really informative. There was things in there I kind of thought, really?
Yeah, I know. Yeah. Some helpful to us.
Yeah, absolutely.
Quite balanced. Yeah.
Absolutely. So, yeah. I hope you enjoyed it today, everyone. I hope you found it useful. It sounds crazy to say Happy Christmas and things like that, but it is. It's probably the last time we'll speak to you from the HRHuddle. So we will be back in 2022, which sounds terrifying. So we'll have more webinars and more employment law updates. So if there are any topics you particularly want us to cover, then please just send me a message on the Facebook group or email me. But yeah, I hope you all have a wonderful Christmas and New Year, and we will see you very soon. And thank you again, Keeley.
Thank you, everyone. Thanks.